Hi everyone, I'm Lori Frank from Lori Frank Mediation and Consulting, and today you're watching part of a video series that I've been doing where I've been going out into the community and interviewing other professionals who are also working to support parents who are going through separation. So today I'm with Laurel Dietz. Laurel is the owner of Alinea Legal Coaching. And Laurel has a unique approach in her practice, and it's a little different than what we might think of.
A little bit different, yeah.
Yeah. So maybe do you want to tell us a little bit about what sort of sets your practice apart from what we might think of as the traditional family law lawyer practice?
Okay, so what I've learned actually in explaining my practice is to explain first what is the traditional practice. So for most people, if you're going through a divorce or a separation, this is probably the largest legal conflict you might be dealing with in your life, with probably the most on the line. So with a traditional lawyer, what you'll do is you go in and you meet with them for maybe half an hour for free, but after that they're going to be asking you for about $2,500 or $5,000 up front. And then they're going to get started on your case once you deliver that money to them. And they will do everything for you. You'll provide them with the information, but they'll write all the letters, they'll organize your information, they'll make sure you're going to the right courses or whatever you need to do. And then they just send you the bill and you keep topping up that $2,500, $5,000. And for traditional legal services, you can expect to spend about $20,000 to $50,000 for your case. Even if you're going to mediation, it can be a significant legal cost to get you there. To have a lawyer sort of give you the best service possible. Now, if you are someone who can't afford this sort of Tesla model legal service, whereas the average income earner often can't, you might decide, okay, well, I can manage a lot of this stuff on my own, and that's where my services come in.
Great.
So with me, what you do is you pay for the services you need, and you don't use or you don't pay for services you don't need. So if you're able to organize your financial documents, make your list of assets and debts and all that, and put everything into a nice neat binder, and also do some negotiation with your spouse, or even write your own letters to lawyers, etc. Then you can come to me and we can discuss I can give you legal advice on your what your legal rights and responsibilities are. We can come up with strategies to how you're going to resolve your issue, and possibly prepare to go to mediation. If you're not comfortable organizing your financial information and that's all you want the lawyer for, then you can hire me to do that. Right. So sort of you pick and choose your services that you want so that you don't have to pay for absolutely everything. It's sort of the Corolla model.
Right. That's a great way of putting it. Yeah, because this is most definitely a time, especially for that sort of middle income earner, finances are a huge stress when people are separating, and legal services are often unattainable, and they end up representing themselves, and sometimes, often we hear really not understanding what they need to be doing.
Yeah, that's right. And so what happens is a lot of people burn out early with all their legal help. So they go in heavy and hard because they're like, I can afford $5,000. The problem is that's all they can afford. The $5,000, that sort of brings them to an end, whereas $5,000 is only going to give you a quick start or a little bit of a start. And that's usually often the easiest part to organize on your own, is the very beginning part. So if you're able to save cost up front and put your funds towards legal services maybe a little bit later down the road, that might be a smarter way to strategize your spending on legal fees.
Yeah, because it sounds like you and I both hold the same value that accessibility is really important. Access to the information that you need, but being able to afford that access. And just picking and choosing exactly what you need. Because like you said, lots of people, they can get their financial documents together, or they can figure certain pieces of things out, but then they really need advice on one or two specific issues.
Exactly.
Or once they get going further into things, something comes up and they want to know.
Yeah.
what'll happen? Am I on the right track? Am I being unreasonable? Am I totally out in left field in what I'm asking for here? Or, so that's where you can come into play.
Absolutely. So, yeah, exactly. Divorce and separation doesn't happen only to wealthy people. It happens to anybody. And the law does provide for fair resolutions. They sort of set out what the base is and like, this is what we say is fair. You can organize your affairs however you want, provided the other party agrees. But there will always be that baseline. This is what we think is fair. And if you end up going to court, this is where we're going to try to get you as close to this line. But if you can't access any services to help you get as close to that line as possible, then the law is pretty much useless to you. So that's why I offer these services, so that you can, even if you can't get all of the services, at least you can get a little bit to get you a little bit closer to where you need to be.
And I think you brought up another really good point there. The way that you offer your services leaves the control still in the hands of the client. Whereas in a more traditional model, I hear sometimes from clients that they feel a little out of control of the process because they've handed things over, the lawyer's taken over, they're doing everything that needs to get done. But with your model, the person still retains more control and says, no, I don't want to do it that way. I want this result out of that. Or they can come up, like you said, you've got this baseline of fairness. They can come up with whatever arrangement they want, as long as it's a legal one.
Yeah, this is true. And I think that has to do with sort of the legal culture. So if you retain a lawyer, we have an idea of how we like to see things, and we want things to go mostly in that direction. What I've learned since opening up my practice here and operating in this way is that there's a lot of families and a lot of people who decide they never actually even want to go to a lawyer because they don't like how we operate. They don't like the solutions we're offering. And so often clients will go directly to the mediator to work out their own solution. That said, they might still need some support after the mediation to make everything binding. And that's where they end up coming to see me. And, even though I can give them the advice, I'm not going to force it. I'm not in a position where I can force them to take any solution that I think is best. It's up to, and I always try to encourage. I always say, this is my legal advice on this solution. Could be some issues here. This is why it's good. This is why it's bad. One way to fix it would be doing this, but you probably already considered that option and you don't like it. As long as you're aware of the risks of your current solution, you have a backup plan. You're free to do whatever you want.
So let's talk a little bit about that then, in terms of the role a lawyer can play through the mediation process, because there's certainly before, during, and after pieces that people may decide that they also want to bring a lawyer into the process for different parts of it. So before mediation gets going, what role might you play for a client?
So that's sort of would go along with my intake process, whereas I sit down with a client, we look at the whole situation, we look at their family, we look at their financial situation, their case, and we come up with what's important to them, what are their goals, what would they like to see happen. We can strategize potential resolutions and proposals to make to the other side. We can identify areas that might be particularly contentious and ways to get beyond that. How are you going to deal with that so that you're not off in left field and think that you're being completely reasonable and the other party is out to lunch. So I sort of bring the client in, we get them sort of centered on a track, and they have and I can help them get everything organized, make sure they have all the right documents, that everything is being shared appropriately ahead of time. So yes, it can be just as short as just doing a consult for strategy and legal advice purposes, to as much as helping getting everything organized and sharing information.
That's great. I know myself, I found every once in a while in a mediation we'll be in the midst of something and we'll get stuck. So both people, one or both, will really dig in and not be able to be moved from their position. And we'll try and work through it, but we're really at an impasse. And I have found in those cases as well, that's sometimes a great time for us to take a break from mediation, they'll go their separate ways and they'll get advice. And so that's maybe another time where they can come to you to get some specific advice on that particular issue.
So yeah, sometimes with that, it's just a matter of trying to think outside the box and trying to come up with another solution, or give advice about how other families have managed the same issue, and potential things they could think about doing. We identify why maybe they're stuck where they are and why they don't want to move. And then what I find is most effective for people is if they understand big picture. So you're stuck on this little issue. Where are you going from there? So if are you going to end the mediation process because of this issue? And if so, how are you going to resolve it? Okay, so what are your options? Your mediation, further negotiation, arbitration, court, and then I give them timelines and what they can expect from each process. And then looking at it, big picture like that, you might take a lot of people take a step back and think, well, actually, this issue that I thought was so critical is not that critical, and I am willing to maybe be a little more flexible in my thinking.
Yeah, so it helps to sort of refocus things for them. And I imagine, too, you can say, well, if you ended up going to court, this has been my experience with this particular issue and how it's played out in court, or what the law says specifically about this. And so they can kind of weigh that and go, okay, I am on track with what I'm thinking, or I'm really not on track. And that sometimes helps them to break that impasse.
Yeah, and I mean, it also goes the other way. Sometimes it will come that, look, you really do need to stand your ground on this. And maybe it's the other party being unreasonable. And that's also part of the legal advice. And it's, I will help clients identify if there are issues worth going to court for, and then they need to understand what the court process is like, because no one wants to be there. It's not a good process. It's only go if you have to.
Yes, because really that is sort of the ultimate on the spectrum of where your control lies. That's the far end of losing control in terms of the outcome is when you end up in court.
Which
and so then at the end of the mediation process, so for myself, what I end up doing is I write a detailed summary of everything that they have agreed to. But I'm not a lawyer, so I cannot write the legal document. And for some couples or ex-partners, that's okay. That's all they needed. They just needed to sort it out. And now they've got it down on paper and they're okay with that. But for many parents, they need to go that extra step and have the legal document as backup for maybe down the road, or if things are really not amicable, they've come to some agreements, but there's still that potential for conflict. And so that's another point, again, where you can come into play.
Yeah, so after mediation, what I offer clients is if they want to have there's the independent legal advice on the agreement they've negotiated, but then also drafting up the binding separation agreement. So areas where that's going to be important is potentially for parenting matters, although I find with maybe 80 to 85% of people, they're going to come around and they will manage their parenting as long as they have the right tools in place. It's where people often need binding separation agreements is where one party is remortgaging or buying a house or something like that. The banks and lenders always want to have a binding separation agreement, and they want to know what your financial situation is. And so people often will come in a bit of a tizzy, not realizing that they need that document. And that's just something to be aware of, to plan ahead for. So go to mediation, get your memorandum of understanding, and then get that turned into a binding agreement as soon as possible if you're dealing with land or finances or any contentious parenting matters.
And you brought up another good point too, is that at the end of mediation, when I am writing up that summary and handing it to them, I always advise that they get independent legal advice before they decide that they want to sign anything or anything like that. So that's an important piece, because it's like you said, they've come up with this arrangement on their own, and as much as we can, we talk about the pros and cons of the agreement that they've come to, but it is still really important to get that legal advice of what could this potentially, what are the potential risks, or what could this look like a year or two from now? Have you thought about this, that, and the other?
Yeah. And that is one of those things that you want the other party to get that legal advice as well, independent legal advice, because that's what's going to make it stick. Mm-hmm. Otherwise, there could be some allegation or accusation in the future if someone wants to set aside the agreement. Oh, I didn't know what I was signing. Yeah. I was under pressure. I was emotional. You know, all sorts of things that, you know, it is hard to set aside an agreement later, but not having that independent legal advice will make it a little bit easier to do that. Mm-hmm.
So what is the best way for people to reach you if they need to get in touch with you about services?
Oh my. Well, we try to be as accessible as possible. So we have, you can check out our website for our pricing. So we try to be as transparent as possible about the services that we have on offer. I mean, you can always discuss if there's anything in particular you wanted and you don't see it on our website. We're flexible in that way. But so we have all our pricing on our website. So that's legalcoach.ca. And you can always email info@legalcoach.ca. And or you can call our phone in 778-977-6551, and my lovely assistant Angela will get in touch with you to set something up. That's phone, email, and you can also check out our Facebook page, Millennia Legal Coaching.
Yeah, and I've linked to that on my Facebook page, so you can find it there too.
And we also have an Instagram account, which I'm working on. It provides little nuggets of advice or help to get you through sort of some of the darker moments of a separation or divorce.
That's great. Well, thank you very much for talking to me today. You are such a great local resource for parents and families who are going through a difficult time. And I can tell that, you know, we both are really, it's really important to us that families have the best opportunity to try and make this as a healthy as possible transition, especially for the kids. You know, they're the ones who often have the least control over the whole situation. Absolutely. So it's important to be able for the parents who are separating to be able to move through this as comfortably as possible.
With a little bit of dignity and control would be
exactly.
Ideal.
Yeah.
Well, thanks for having me. I've really enjoyed talking about this with you. It's one of my favorite things to talk about.
That's great. Me too. Okay, well, thanks everybody. That's it for today. We'll see you next time.